Good afternoon. Today I'm going to discuss a very recent High Court of Australia decision on tort law, Hunter and New England Local Health District and McKenna, 2014 High Court of Australia 44, handed down on the 12th of November. Fascinating case because in it the High Court, in about 40 paragraphs, looks in detail at some of the fundamental issues that arise with respect to determining whether there's a duty of care owed in tort. Always a very tricky question. And the background of the case is an appeal being brought by a hospital or local health authority with respect to its care of a man who was suffering a pretty severe mental illness. And he was detained and he was certified that he had a mental condition, but in order to assist him, I guess, or facilitate his recovery, he was released into the care of a friend, a good Samaritan, who Mr. Rose, who came and picked him up from hospital, and they set off to travel back to Mr. Pettygrove, who was the mentally ill patient, Mr. Pettygrove's home in Echuca in northern Victoria. And unfortunately, in the course of the journey, Mr. Pettygrove kills Mr. Rose, and he did so, as he told the police, on impulse, because he believed, under the subject of course to his paranoia or his illusions, that Mr. Rose had killed him in a past life. And sadly, Mr. Pettygrove later takes his own life, and the people who are suing are relatives who, of course, are upset, to put it mildly, I guess, by the sudden death of Mr. Rose. So, was there a breach of duty here by the health authority in releasing Mr. Pettygrove? And that needs to be seen against the backdrop of the Mental Health Act 1990, New South Wales, which prescribes various things the doctors have to do, which we'll look at in a moment. Justice Elkheim in District Court said there was no duty owed. A Court of Appeal overruled him and held that there was a duty of care not to release Mr. Pettygrove, who was mentally ill, into Mr. Rose's care or sole care to get him back to Victoria, where it was intended that he would be able to get some further treatment. And a question, of course, then arises as to whom is the duty actually owed. Health Authority took many grounds on appeal to the High Court, alleging there was no duty owed pursuant to Section 5B, that there was a question of competent professional practice, Section 5O of the Civil Liability Act, and questions of special statutory powers. But in the end, the High Court, from paragraphs 13 onwards, look in detail at the question of whether there was any duty owed. And in doing so, the Court takes us back to Sullivan and Moody, which is a case decided in 2001, 2007 CLR 562, or 2001 High Court of Australia 59, where the High Court says, at paragraph 50, that a lot of problems can arise, don't we know this, in relation to determining whether there is a scope of duty or an existence of a duty of care in tort. And the court said this, it said, sometimes the problems may be bound up with the harm suffered by the plaintiff, as for example its direct cause is the criminal conduct of some third party. Sometimes they may arise because the defendant is the repository of a statutory power or discretion. Sometimes they may reflect the difficulty of confining a class of persons to whom a duty may be owed within reasonable limits. And sometimes they may concern the need to preserve the coherence of other legal principles or of a statutory scheme which governs certain conduct or relationships. The relevant problem will then become a focus of attention in a judicial evaluation of the factors which tend for or against the conclusion to be arrived at as a matter of principle. Well, of course, if you've been listening to the four categories, as it were, that the High Court enumerates in Sullivan and Moody, you can see that each of them, in fact, is attracted here. We've got criminal conduct, of course, by Mr. Pettygrove. No doubt about that. Secondly, we've got the question of a repository of statutory discretion. Doctors have a power to hold or not hold according to the Mental Health Act and its criteria. Then, of course, there's a question of indeterminacy of duty, because the people who are complaining are, in fact, the relatives. They're not Mr. Rose, who's sadly deceased, but they're relatives of Mr. Rose who have suffered psychiatric or grief issues, of course, with him being sadly killed. And then you've got the problem of coherence. You've got several different regimes operating, including the Mental Health Act and the question of a statutory scheme. And the High Court points that out, paragraph 19. Every one of the four examples given in Sullivan was relevant in this matter. Relatives claim presents issues about the nature of harm, about the exercise of statutory powers and discretions, about indeterminacy of class and about coherence. These reasons will show that the second of those considerations, statutory power, is determinative. But that conclusion should not be understood as suggesting that the three other considerations which have been mentioned, nature of harm, indeterminacy and coherence, are not relevant considerations, bearing upon whether the hospital or the treating doctor owed the relatives a relevant duty of care. Now, the question, of course, is whether or not Mr. Pettygrove should have been released from hospital. And at trial, it was argued for the relatives that it was negligent to release Mr. Pettygrove into Mr. Rose's care. But what does the Mental Health Act say about it? Well, Section 20 of the Mental Health Act, set out at paragraph 25 in the judgment, says this: a person must not be admitted to or detained in or continue to be detained in hospital unless the medical superintendent is of the opinion that no other care of a less restrictive kind is appropriate and reasonably available to the person. So you've got to find out that there's no other less restrictive care appropriate and reasonably available. And you can see here, of course, a policy decision, I suppose, which the legislature is making. We don't have bedlam anymore, or lunatic asylums. We don't lock people up and keep them under restraint day after day. It's a balancing act. I guess the community's come around to the notion that care and community is the appropriate way to proceed for people who are suffering from mental issues, provided, I guess, that they're suitably medicated and supervised. And that leads to the conundrum being faced here, in a sense, because was there no other less restrictive care available? That, I guess, depended on the view you took of Mr. Pettygrove's mental condition and whether or not transporting him back to Echuca via Mr. Rose's kind officers was going to be equally appropriate. And as the court points out, these features of the Act, paragraph 27, presented a medical superintendent deciding whether a person should continue to be involuntarily admitted. First is the question, is the person mentally ill or disordered? And secondly, if yes, is there no other care of a less restrictive kind which is appropriate and reasonably available? No doubt, paragraph 28, each question required clinical assessment and judgment, and each had to be answered either yes or no. But if the person was judged to be mentally ill, the Act required not only that any restriction of liberty and any interference and self-respect be kept to the minimum necessary, but also, unless the medical superintendent was of the opinion that no other care was less restrictive, the person was not to be detained or further detained. So determining a person was mentally ill did not entail the person must or continue to be involuntarily admitted into hospital. And when we look at the duty here, we can see that there was an obligation imposed by Section 20 not to detain, and performance of that obligation would not be consistent with the common law duty of care requiring regard to be had to the interests of those or some others with whom the mentally ill person may come in contact when not detained. If a suggested duty, according to Sullivan's case, gives rise to an inconsistent obligations, that would ordinarily be a reason for denying that the duty exists. So, if a hospital, paragraph 30, or doctor would owe those with whom a mentally ill person may later come in contact the duty to take reasonable care, to protect those others from the risk of physical harm or psychiatric injury caused by learning of physical harm done by the mentally ill person, the hospital or doctor will be required to ask whether that risk is foreseeable and not insignificant, and then take whatever steps a reasonable person would take in response to that risk. Foreseeable risks are those that are not far-fetched or fanciful. And paragraph 31, if a person is mentally ill, the risk of that person acting irrationally will often not be insignificant, far-fetched or fanciful, and in such a case there'll often be a potential consequence of adverse consequences. It may be that the mentally ill person will engage in other physical consequences, and in some cases, perhaps many, the position of a hospital doctor would respond by continuing to detain the patient for as long as she remained a mentally ill person, thus avoiding the possibility of risk of harm to others will eventuate. But, of course, that is not what the Mental Health Act requires. It requires the minimum interference with the liberty of a mentally ill person. It required the person be released from detention unless the superintendent formed a view, but there was nothing of less restrictive kind available. And so here, it's not the point to decide whether, as the relatives alleged, the medical superintendent did not positively authorise the release from hospital. So, once you've got that position, of course, there cannot be any duty owed. And conclusion, paragraph 34, this being so, it's not necessary to consider the extent and potential indeterminacy of a liability which imposing a duty of care would entail. or to look at the question of the harm suffered because of the unlawful act of Mr. Pettygrove. Well, there you have it. Interesting case, classical case I suppose in a way, one which no doubt torts lecturers and teachers will be looking at in some detail. It captures the essence of the modern dilemma in terms of a duty of care, particularly when you have a statutory regime which sets out the way in which certain activities ought to be undertaken. And you can see there, of course, pursuant to the Civil Liability Act, which you've got the possibility of some sort of risk of harm arising, which is avoidable and not remote. But on the other hand, of course, you've got a positive duty not to restrain the person, that's to say to keep the person involuntarily detained who is mentally ill, unless there's nothing else available, which is reasonably available and is less restrictive. And looking at it from that perspective, of course, there was no basis upon which Mr. Pettygrove could be detained. Well, difficult question, isn't it? As always now. We've got a balancing act with a lot of questions in society. Mental Health Act makes a choice about it. Whether or not it should be altered, the regime should be tightened, difficult to know. But of course, no one really knows, I guess, what's going to happen in terms of psychiatry. It's more an art than a science, difficult at the best of times. We've had a few recent cases where people have been released and then committed terrible offences, family members, and in this case, a poor fella doing a good turn. But I guess that's got to be balanced against the wider proposition that it's better for the vast majority of people who aren't at that level of danger to others or themselves to be released and treated appropriately. So have a good look at the case. Interesting case. Summarises all the modern dilemmas with respect to the law of tort. Difficult to know where it's all going, of course. It seems to be a wilderness of single instances, to quote the famous poet here, doesn't it? That's difficult in terms of duty of care. We get cases every week which we look at. This case, I guess, summarises one aspect in some detail and has the benefit of being a short judgment and a joint judgment, which is always to be appreciated when delivered by the High Court.